Russ Latino is president of Mississippi, Empower Mississippi, and a noted attorney, as I mentioned. And did you watch? Did you listen? Did you hear? And
I listened to it yesterday. It's look, I don't think people realize how potentially impactful this is. Once a generation, you might have a case like this that has profound consequences, not just in the state of Mississippi, but really across the nation, and truthfully not just in the context of abortion, but it's a bigger question about the role of courts. And so, if you look at sort of the history leading us to this moment, you see a history of extreme judicial activism. It started in 1965. There was a case called Griswold v. Connecticut, Paul, where the Supreme Court created a right to privacy that they said prevented a state from making decisions about things like contraceptives. At the time, the court said that right, while it was nowhere in the actual Constitution, was found in the penumbras and emanations of the 14th Amendment. Mm-hmm. And you might be saying, well, what in the wide world of sports is a penumbra? It's a Latin derivative word for a shadow. So the judge was saying there's a shadow in the Constitution that suggests that this right exists. Fast forward to 1973, and that's when Roe v. Wade comes down. If you actually look at Roe, a lot of people interpret Roe today as saying that you can't have abortions, or that you can't prohibit abortions before the point of viability. The Roe decision actually created a trimester system. It said in the first trimester, you can't prohibit abortions. In the second trimester, you can begin to regulate abortion. And in the third trimester, you really can't outlaw it altogether. So there was a line in Roe that said something about viability. And the guy who wrote Roe, Justice Blackmun, in his personal notes said it was dicta, which means it really wasn't intended to affect the way we thought about policy or the way we thought about a constitutional right. Fast forward to 1992, there's a case called Casey v. Planned Parenthood. And Casey decides to look at Roe and say the entirety of Roe, the decision, was that anything that happens in that pre-viability stage, you can't prevent abortions. You can't place restrictions on abortions. So they took something that the guy who wrote Roe said was dicta, and they turned it into the principal holding, and then they added something. They said, in addition to that, anything that places an undue burden on access to an abortion is unconstitutional. And so what they did is they created a subjective standard that made it really hard for states or policymakers to know what restrictions and regulations can we put into place that potentially could protect an unborn child. So the case that is pending in front of the Supreme Court now, the Dobbs case, the way it's set up is that in 2018, and you know this and your listeners may as well, but in 2018, the state of Mississippi said, hey, look, we're going to implement a thing that says that after 15 weeks in the gestational period, you can't go and have an abortion. Well, that cuts against this notion that how Casey interpreted Roe, which is pre-viability, you can't limit abortion. So it sets up this sort of epic challenge to whether or not Roe and Casey and sort of 50 years of abortion precedent have any merit or any grounding in the Constitution. And I thought that Solicitor General Scott Stewart did an excellent job yesterday, obviously appointed by the Attorney General. Thought he did a really good job of explaining the fact that this is just not rooted in the Constitution. Those previous decisions were judicial activism.
Then, for you lawyers, have stare decisis, is that how you pronounce it?
Yeah.
And I think Sotomayor was talking about that, and she used the word stench in here, and you know which way she's going to go.
Sure. The newest ban that Mississippi has put in place, the 6-week ban, the Senate sponsor said, we're doing it because we have new justices on the Supreme Court. Will this institution survive the stench that this creates in the public perception that the Constitution and its reading are just political acts?
And then I'm reading a story where it was either Kavanaugh or Alito, one of them tackled her on this one, that this has been done a lot as far as president is concerned. Go back and revisit it. And if the argument is over viability, wouldn't that change with technology?
Yeah, I mean, first of all, stare decisis is essentially a system of deference, right? It's looking at previous cases and trying to understand or put yourself in the shoes of the judges that made those decisions, not just to wholesale discount whatever they thought and replace it with a new set of ideas. That doesn't mean you can't overturn bad precedent. Certainly, there's a ton of examples, including cases where Justice Sotomayor and Justice Kagan have signed on to overturning precedent. The biggest example that people point to is in the late 1800s, Plessy v. Ferguson said that you could have separate but equal, right? That segregation was okay. 58 years later, Brown v. Board of Education comes along, and they recognize that there just was no constitutional principle that actually undergirded Plessy v. Ferguson.
So what was she talking about, though? How would she make that statement with any credibility at all?
Yeah, I mean, look, the stench, if you will, is in ignoring the fact that there is no constitutional basis for an argument that says it is a constitutional right to an abortion. Something that people need to understand is this case isn't about saying there's a constitutional right against abortion. The case is about, is there anything in the Constitution that speaks to this? Because if the answer is no, then it's a policy decision that needs to be made by state legislatures.
Yeah. Justice Kavanaugh suggested overruling precedent has been an important part of the court's history. And he said, if you think about some of the most important cases, the most consequential cases in the court's history, there's a string of them where the cases overrule precedent. If we think that the prior presidents are seriously wrong, why then doesn't the history of this court's practice with respect to those cases tell us the right answer is actually to return to the position of neutrality and not stick with those presidents in the same way that all of the other cases didn't? So, in other words, if it is wrong, then we got to go back to what it was, so it's right.
Yeah, I mean, the Supreme Court should not ignore that which is blatantly not rooted in the Constitution. And one of the interesting things about the arguments yesterday, and I said this was going to happen before it happened, not because I'm smart, just because I knew it was going to happen. The arguments were clear. One side was going to be talking about what is and isn't in the Constitution, and the other side was going to be talking about the reputation of the court or preserving previous rulings. The reality is, if you look back at the Roe decision and you look at the dissents, there were two dissenting voices in the Roe decision. Justice Rehnquist was one. The other one was Byron White. Well, Byron White has publicly talked about, it's throughout sort of his history, that he was pro-choice. And he's even said before he passed away, had I been in the legislature, I would have voted in a way that was pro-choice. But I recognized essentially that there was nothing in the Constitution that would suggest that the court had a say in this, that it was anything other than a policy decision. And part of that is, if you look at the 14th Amendment, which is the basis for the argument that there should be a right to abortion, the 13th, 14th, and 15th Amendment were all in a response to slavery. It was getting rid of slavery. It was making sure that people who had been in that system could be acclimated into society and would be treated equally. At the time the 14th Amendment gets ratified, virtually every state in the United States had a ban on abortion. So the states had already asserted the right to ban abortion at the time that the 14th Amendment was passed. Well, if the intention of the drafters had been to allow or to create a right to abortion, they could have addressed it then very explicitly. They did not. This is clearly sort of a manufactured thing that was designed to create a policy preference that the court had no business creating.
It is amazing that simpler minds without law degrees, I know we're under the gun here, but just thinking that, number one, as far as viability, if there's something growing in a woman's body, then it's either a tumor or it's a baby. And if it has to be eradicated, there are not a lot of options on this.
Well, viability, to your point, is a scientific standard. It's not a legal standard.
No. We'll talk more about